Ready for the case of Avenarius versus State. I normally try to check my pronunciations, but I know Mr. Kilberg is here for today for the State. Mr. Klapatauskas, how'd I do? Wow, there you go. Okay. Mr. Kilberg, you may go.
Your Honor. May it please the Court, Counsel, Madam Chief Justice. As you said, my name is Nick Kilberg, and I'm here on behalf of the defendant and appellant in this case, the State of Iowa. Officer Avenarius accidentally shot herself in the thigh while on the firearms course at the Iowa Law Enforcement Academy's Firearms Instructor School. She now seeks to hold the state liable, alleging that her trainer, Officer Molly Jansen, was negligent in instructing her. However, before starting at the academy, Officer Avenarius signed a form titled Waiver, Release of Risk, and Assumption of Liability Agreement. And she agreed to hereby waive, release, and hold harmless the state of Iowa, the Iowa Law Enforcement Academy, and all their agents and employees from any and all claims, demands, rights, causes of action, and judgments of whatsoever kind and nature arising out of any injury sustained.
Mentioned anywhere in that waiver?
Your Honor, it is mentioned. It's mentioned there at the top with the Firearms Instruction School, as well as at the bottom when it refers to releasing any risk arising out of the above reference training.
Looking at the waiver.
Right at the top, Your Honor, Firearms Instruction School, and then at the bottom it refers to any risk arising out of the above reference training.
I was working out at the Y this morning. It looks like a release from a gym. It's talking about training program, physical activities, rigorous physical training program. Am I misreading it?
But I think it's important to keep in mind the identity of the parties and the context of this waiver. Officer Avenarius was an 8-year veteran of, I believe, the Dubuque Police Department with extensive firearms training, coming into a school that was specifically for instructing others in the use and carrying of firearms. I think that context has to be understood when reviewing the releases language.
It is all claims. What does that refer to?
I think it's extremely broad.
It's
As a matter of public policy, this court has determined that it cannot cover those, that the release cannot waive those claims, but that's a matter of public policy rather than of understanding what the words themselves say.
conduct.
Same, Your Honor.
Would the plaintiff in this case know that those claims are not covered?
I don't think she would, Your Honor, or she might not. I certainly wouldn't say what her knowledge is, but at the same time, in the process of construing the words have to be read to mean what they say, any and all. And again, I recognize that this court in the Lucan case held that I believe it was reckless and intentional conduct couldn't be waived. But at the same time, that is a judicial policy decision rather than a reading of the language.
Sort of waiver form, kind of hoodwink people into believing that they didn't have claims that they actually do?
Your Honor, I think that's perhaps the reason that we have fine counsel such as Mr. Klapatauskas over here who can inform them of their rights after the fact. Now, I think that it's important to be cognizant of rights going in. It's not expected that a casual reader would know every single legal nuance that might arise, but I think that this form attempts to capture that and certainly cues even a casual reader that garden variety claims such as negligence would be released.
And that's what this case is a straightforward negligence claim, right?
There was, I believe, an attempt to amend to add a gross negligence claim, which the court below denied as becoming too late, and I think would also be covered or released anyway under this court's analysis in the Lucan case.
Our cases suggest that the release needs to have the word negligence in it, and this one doesn't, although it's quite broad. Is this case an opportunity to say, as the Court of Appeals did in the Corsmo or the water skiing liability waiver, that you don't have to say negligence if in context it's clear you're giving up your right to sue?
It would be an excellent opportunity for the court to make that clear. I think, as in Corsmo, the language here stands as being clear and unambiguous that any and all claims language, again, says what it means. I would also refer this court to the Wyke v. Ace Rents case. That was a case from 1958, and I can provide the citation if the court would find it helpful. But that was a case where a man rented a lawnmower from a rental company, and he was injured while using it. And he had signed a waiver that said he did hereby exonerate, indemnify, and save harmless the company from all claims or liabilities to all parties for damage or loss to any person arising out of that use. And this court said that that language was so clear and unambiguous in including the alleged negligence of the rental company that the court didn't even need to engage in the process of construction. It simply read the release itself and said, this is clear, this is unambiguous.
It seems like we've recognized that there's kind of three ways you can do this. You can require, some states require you have to use the word negligence. Some cases say any and all means any and all. And it seems like our cases have kind of picked a middle ground, which we've kind of reaffirmed in Lucan, that says read in context, and it kind of depends on the context. It needs to be clear and unequivocal that you're seeking to release your own liability. What part of this release would let Ms. Avenarius know that she was also releasing not just general inherent danger from what was a dangerous activity, but also the state's own acts or omissions?
I think I would again refer to the language of the release, which is very specific in releasing any and all claims, causes of action.
I think we've recognized the difference. Any and all, some cases do say, or in some states say, any and all means any and all. But I think we've rejected that and said it needs to be more explicit when you're talking about your own activities.
Well, Your Honor, I've read this court's prior cases and the cases from the Court of Appeals to require clear and unambiguous language. And I think that any and all language is clear and unambiguous, subject to the judicial exceptions that...
So is a release just says, I'm releasing any and all liability for any and all injuries, period. And then the defending party is off the hook.
I think that might not be sufficient, Your Honor. And I think it again goes to both the language that is used. It's not just if you signed a release that said, I waive any and all liability, period. I don't think that would be sufficient.
Following up on what Justice Oxley was saying, I mean, you do read the language in it, and it says, you know, any and all, it does have that very broad language during the above referenced law enforcement academy training, including physical fitness training. And there's all this emphasis on physical fitness, and that might lead me to believe, okay, if I have a heart attack, I'm not going to sue them, okay? But, you know, we're talking about something that happened that was very different. As Justice Oxley mentioned, it's the alleged negligence of the instructor in telling Ms. Avenarius what to do with her firearm.
It goes back, Your Honor, to the context and the identity of the parties. Firearms are inherently dangerous. They come with inherent risks. And an officer of Avenarius's stature and experience would know that. She would be intimately familiar with these risks. I believe there was evidence in the record of her doing twice annual firearms certification. She was not a greenhorn to this type of experience. Furthermore, that because this was a firearms instruction school, there had to be some kind of hands-on training going on. That's simply inherent to the nature of a school. And so I think that is the kind of context that puts the agreement into place and makes it clear what kinds of risks she would be facing.
That seems to cut against your argument, because if it's an inherently dangerous activity, then it seems like the release is from injuries that would flow from the inherent dangerousness, as opposed to injuries that would flow from the negligence of the person that's supposed to be training me, telling me to do something that's against the industry standards.
Again, Your Honor, I think that it goes back to the nature that this is a firearms instruction school. That's clearly presented on the waiver. It's inherent, again, to the activity that's being carried out. This is about training. It's not just about going out and shooting a weapon at the range. It's about being trained. It's about training others to train. So that is implicit in what's going on here, and that would be apparent to even a casual reader.
If you're talking about training in schools, we've cited the Mississippi case of Turnbro. We decided that in Sweeney. Are you aware of that? That's the scuba diving case?
Yes, Your Honor.
Can you address how that plays into this case?
I apologize. I don't have the exact language of that case here in front of me, but as you're right, I believe he said there that he released any liability arising from the inherent dangers of diving. I think that this case, again, is different because Officer Avenarius was experienced with firearms. She was going into being trained and to train others. So the context simply distinguishes this case from that Mississippi case.
Green came in, doesn't have the experience that this officer does, and the same situation happens. That person would be treated differently?
Someone who comes in and has no firearms experience would not be at this firearms instruction school in the first place, Your Honor.
Well, we have to take into consideration she has 10 years experience. Imagine somebody who doesn't have 10 years experience. Where in the record does it say that you had to have 10 years experience to even sign this document?
As I have said before, was an experienced officer. This is not something that a member of the public can walk in and participate in. This is something where Officer Avenarius had to, I believe, apply. I know that she had to seek recommendation from...
Different than anyone else. You keep telling us she has 10 years experience. So actually, she is anyone who could have signed this. You're saying that she's the typical person that would have signed this.
Yes, Your Honor, people who signed this particular waiver. Now, the result may have been different if she had walked in off the street, as in the Baker case, but I think that's a very clear distinction here. You have to look at the context of the parties, their identities, what they know coming into this release, rather than just simply throwing it out as a blanket matter. Further, I think there was also, at the appellate level, the issues of unconscionability and the public policy argument were raised. This court has previously found that...
Said many times that it's not against public policy to have waivers of liability. Is it potentially time to rethink that generally, or in the specific context of required firearms training for law enforcement officers?
In the court's prior cases talking about this public policy, it realized that there's an inherent tension between the notion of tort law, in which seeks to right wrongs or help injured parties, and contract law, which seeks to allow freedom of contract, including including allowing parties to apportion their own risks among themselves. And the court has previously recognized that that freedom of contract is a very strong public policy goal.
Different, though, when you're talking about, for example, Lucan, which I think was zip lining, if I remember right, versus some sort of mandatory training or state-provided training where, to advance in her career, she doesn't really have necessarily any other options other than the Iowa Law Enforcement Academy to do the training. So it's not really voluntary in that sense, right?
It is voluntary because this was not a requirement to keep her position, is my understanding. It's a requirement to advance in a specific role. Further, I think that the distinction is that if the state is not able to appropriately apportion risk and the parties aren't able to do that for themselves, there would be the risk that the state would simply find it not able to do these kinds of trainings, and that would leave room for outside parties to come in, third parties who might have inconsistent standards or lower standards, and that would actually work against public policy. It's important that the state be able to do this.
Yes, wouldn't the same rule apply to these hypothetical third-party vendors? I mean, they would all be operating on the same legal standard.
That's a position that perhaps these third parties could then evaluate for themselves, whether they wanted to have to take on that risk. But I think that simply setting it as a sharp dividing line that the state can't do this might very well lead the state to recede from doing this type of activity. And it's important that the state do it. It's important to have consistency among officers. It's important to have this specific style of training.
Don't tell me if it's outside the record. This is considered part of her job? Did she get workers' compensation benefits, if it's in the record?
My understanding is that this is not considered part of her job. This is to seek a specific path of advancement in her career. I can't speak to the availability of workers' compensation, and so I wouldn't want to say something that I didn't know to be true. I do see, again, that my time is starting to wind down. So I want to say, in conclusion, again, this language releasing any and all claims, causes of actions, rights, demands, etc., was clear and unambiguous in releasing, including the state's own negligence. Further, as we discussed, the waiver is not against public policy, and I don't want to spend any more time than I have to on the issue of the contract of adhesion. I think that collapses the analysis with unconscionability, which this court has already addressed. So, thank you very much.
Klapatauskas.
May it please, sorry. May it please the court, counsel. Todd Klapatauskas for the Ms. Avenarius. I'd like to address some of the things that were brought up by the justices. Kate Avenarius was a police officer. That was her third primary role in her life. She's a mom and she's a wife. Her career advancement was based on being in a paramilitary-like system. You follow orders, you follow commands, don't ask questions, do what you're told. She did that for 9 years, and she advanced. To get to the next level, she wanted to become a certified firearms instructor, not just a firearms shooter. This is what she had to do. She did it. She relied and trusted on the Iowa Law Enforcement Academy to provide safe, reasonable instruction. When her instructor, her teacher, but really her commander came in and said, I want you to try something new on this live firing range, she turned to the instructor and said, I've never been taught that before. But Officer Avenarius is an officer, and she did not want to go against her commander. So the very next round, bullet goes through her leg. The state is looking to hide behind a piece of paper that we have had 4 very intelligent justices, district court judge and 3 court of appeals judges, who have looked at this piece of paper and said, just looking at it, this is not enforceable.
Our authority is in Iowa, you don't have to mention negligence, right? That's our rule.
Magical word request, correct.
So why isn't all claims, demands, rights, causes of action, judgments whatsoever kind and nature arising from by reason of any and all known and unknown, foreseen and unforeseen physical or mental injuries and consequences? Why isn't that enough?
Isn't it? It's a lot of words, and it certainly appears on its face as, oh my goodness, this is a catch-all, throw it all up. But it's missing some key terms that the Sweeney Court and the Baker Court, and they talked about, well, you gotta have a clear, unequivocal message. You gotta talk about, we have repeatedly held, and this is the Lucan Court cited Sweeney, cited Baker, and said, we have repeatedly held that the contracts exempting a party from its own negligence must contain clear and unequivocal language that by signing she agrees to waive all claims for future acts or omissions of negligence. In this 2-page document, 2-sided document, there is no reference to the states or its
Issue in polling and Baker and Sweeney is that you had documents with one title, permission slip, what was it? Lease, and then a cosmetology contract. And then within that document, you had a single sentence about waiver of liability, whereas here in all caps at the very top, it says waiver, release from liability, and assumption of risk agreement for non-state employed law enforcement officers. So she had noticed that this whole document was about waiving rights versus, a lease agreement.
I would certainly concede that part, Your Honor, that's what it says at the top. But it also then, I think the courts have said, but you have to then have some meat to the document that says, references some reference to the state's own conduct, their acts, fault, omissions, something to the state's actions, conduct. And that's what Sweeney and Baker have honed in on is you gotta have that type of language.
If it doesn't need to have magic words, what should it have said to put Ms. Avenarius on notice?
Anything that would have said something to the effect of the state's conduct, omissions, actions, or the employees will not sue. I mean, even references to a covenant not to sue or will not bring suit. Those are some words that would highlight and send out a message to a person like, oh, ooh.
Harmless, what does that mean?
To you and I, it may mean something. I don't know if to the regular person I don't know what hold harmless means necessarily to a common person. That was very, I didn't mean a common person that's ignorant. I mean somebody that doesn't deal with that type of language on a daily basis. I don't think hold harmless, Your Honor, alerts someone to say, hey, I'm signing up that if my instructor, who I'm required to follow the instructions and commands, tells me to do something very dangerous, by signing this, I'm waiving my right to bring a suit against them.
It says all claims, right? If she had a question about that, couldn't she have said, well, does this mean that if you tell me to do something that, causes me harm, that I'm still liable for it?
Potentially. I think there is an inherent part of it that there's an inherent trust that when you go to an academy, in a school like this that's specialized in for people that have this type of training, that they're not going to give you unsafe directions, especially because of the inherent risks of where we're going. We're going to firearm training, live shooting ranges, excuse me.
Kind of percolating here, this precision myth that, we should have really long, kind of lawyer-drafted documents that people don't read anyway. And doesn't this just sort of cut to the chase a little bit and say, look, all claims, that's it, everything that happens here, we're not liable for because we recognize, and you do too, that this is a very dangerous situation?
If it would require a full paragraph or a whole bunch of more words, I would maybe agree with you, Your Honor. It would require another sentence. And the zip line, from Lucan, and the cosmetology school, and the racetrack case, and all the cases that are in this field or this arena, it took a sentence. It took a sentence to put it in. And those cases, Sweeney since 2008 or 2009, Baker was 1988. The Supreme Court has been speaking to the public saying, hey, best practice, footnote number 2 in Sweeney said, best practice, just put it in there. Put people on notice. So I don't think it's overly burdened. I don't think it's burdensome, period, to put in a sentence that says negligence, conduct, actions on the part of the academy or its instructors.
In cases involving recreational or voluntary activities and the kind of training that was involved here make a difference?
I think it does in the sense of, I think if Your Honors get to the public policy part of it, I think from a public policy standpoint, this should be unenforceable. I think it should be unenforceable at the beginning, but if Your Honors get to the point where we think it is, but is it as a matter of public policy, this is not a recreational activity. And the factors set forth in Baker on, I apologize, Baker set forth the factors when we're talking about public policy situation. That was involving a cosmetology situation requiring a license for the common good. Certainly training firearm instructors, police officers, that is for the common good. We think that from a public policy standpoint, this should be held unenforceable.
That's the problem with public policy. It strikes me that could cut both ways. You could say, a recreational activity that's less important, that's less socially beneficial, and therefore why are we going to exempt people that sponsor recreational activities from liability? But firearms training is really important, so we need to protect people that offer firearms training from liability. I mean, it cuts both ways, these arguments, don't they?
I guess the way I read it, Your Honor, is that we need to protect the victims in these in these situations involving firearms instructors. I don't think we're protecting, the way I read it is, if it's a public policy in this situation, we're not going to protect the entity that's trying to escape liability. At least that's the way I read it. And that does make sense, that, hey, if you're going to try to escape liability in these situations that we're serving the public, put the sentence in, put the words in. Words do matter. So just put it in there. And counsel paid a compliment to myself. I pay a compliment to the state. I imagine that the state has attorneys who review this court's decisions that can go to the academy and say, listen, we have you having people required to sign this form. Put in the words. Put in the words, because I refer back to the district court and the 3 Court of Appeal justices. I mean, they looked at it and they're like, well, we don't think this would alert someone. They're not unreasonable people, and they have all law degrees. We're dealing with a situation where, yes, we have somebody that's, obviously Miss Avenarius is very intelligent to get to where she's at, but this doesn't alert someone to say, hey, if the firearms instructor provides you dangerous instruction, when you sign this, you don't get any claim against them. I don't think that's was alerted. That was not an alert provided to her when she signed it.
This is just a negligence case at this point. There's no claim for gross negligence or recklessness?
Is not. We did move to amend at the summary judgment level, Your Honor. Because I guess my hope would be that the district court declined that at the time because the district court denied the motion for summary judgment. So that was, I don't know, I won't say that was moot, but.
It is whether the wording of this waiver document extinguishes a negligence claim or not.
At this point, at this stage, yes.
The discussion of they just need to add another sentence, and our cases have been out there a long time, and I kind of shake my head that we don't see a explicit including the negligence of these, release parties. But whatever we decide today is going to affect the enforceability of liability waivers in a wide variety of recreational kids sporting events, marathons, all kinds of things. There may not be a lawyer writing it, and yet if lawsuits increase, sponsorships go away, the recreational opportunities are fewer. So there is a backdrop of public policy where we want people to know that if they sign something that says I'm giving up all claims, any claims against all these people connected to the event, that's going to hold up.
I don't disagree with you, Your Honor. I think that if we're going to set a policy, if Your Honors are going to set a policy, then let's have it be a fundamentally sound, based on precedent that says, put the language in there. It's not that difficult. And these forms that are at these various activities and fundraisers and you name it, recreational activities, it's not that burdensome. It's not that burdensome. And I guess I don't see that as a dampening of people going out and doing those things to begin with, because there still has to be negligence as well, so.
Isn't part of the issue, though, like these waivers and releases of liability, they become more complex, the sentences are horrible, they're long, they're redundant, and it's because we keep encouraging lawyers, when we say any and all actually doesn't mean any and all. You have to say any and all, including but not limited to negligence, gross negligence, recklessness, willful, wanton. Why don't we just make it easier and say any and all means any and all, or decide that actually as a matter of public policy that they just shouldn't be enforced? It seems like the worst way is to say any and all doesn't mean any and all, And then you have to create this incredibly long, complicated paragraph that nobody understands.
I think the courts throughout history here in Iowa have said we don't agree with that, having that blanket policy of any and all means that. So we're going to require to at least alert the person. If you want to escape liability, put in the it's not extensive. Put in the sentence that references the person that's trying to escape liability. Put in that it's your conduct, your actions, or your employees. It's not that extensive, and maybe I'm naive about that, Your Honor. So my time is up. I don't know if anybody has any.
Thank you. Mr. Kilberg. While you're walking up, that policy issue, why not? It seems, are you hiding the ball? Why not put it in there? Wouldn't that be, or let me ask you this. Do you wish it was in there?
Your Honor, I fear that might kick off a drafters Olympics. This court, my fear is that it wouldn't stop there, because then,
Stops there. Just one word. What's the harm?
Your Honor, one word would not cause harm. But my fear is that it wouldn't stop there. If we stop the hypothetical there, then sure, I wish it were in there. But if we look at the real world and the way that releases have proliferated in this world, and the language in which the language in releases has proliferated, it doesn't stop at, I release my own negligence, or we release the other party's own negligence. It becomes causes of action X, Y, Z, A, B, C, and then someone else says, but you didn't release D, E, F. That must mean they're not included. And so requiring any and all, including the releasee's own negligence, undermines the meaning of the words any and all. That's my fear.
I mean, the irony is, in this case, that's kind of what your client did. I mean, they have, after the basic release language, then there are all these boxes you have to check that really have nothing to do with the actual training program she was in. I mean, if you want to talk about superfluous language, right?
Is that there was a physical activity component to it, so I don't think it's entirely superfluous, but I do think that the presence of those is perhaps a symptom of exactly the fear that I'm talking about, or the illness that I'm talking about, where our society is becoming ever more litigious, and in the fear of losing unambiguity, we're becoming less understandable. And I think that's...
Litigation is about the word negligence.
Yes, Your Honor. But again, I would refer the court back to any and all, meaning any and all. It's a simple logical construction. And if this court wishes to carve out own negligence from any and all, it has the power to do so, but I think that would undermine the clarity of the language.
I take that point. It strikes me that here the issue isn't so much the type of conduct, but whose conduct. And so it wouldn't be having to list, negligence and other causes that could be pled, but who gets to be released from conduct. And is that such a big problem?
I hope I'm understanding your question correctly, Justice.
So the state here didn't expressly put in this document that its own conduct would be released. And really, that seems to be the only issue. It's maybe not so much that negligence wasn't stated, but that their own conduct wasn't stated.
To the extent that Your Honor is concerned with the who is being released here, there was clarity there. The release specifically released any agents or employees of both the state and the Iowa Law Enforcement Academy. And again, I think that language was included right there on the face. It wasn't being hidden in fine print or anything like that.
It identifies the who, but not for whose conduct. And I think one of the issues I think that this case raises that might not come up in other cases is that it is an inherently dangerous activity already. And so isn't it reasonable for a person who's signing this to look at this any and all language and then the check boxes that say, I understand, about the physical activity part of this, that it's focusing on the inherent dangerousness of the activity itself rather than conduct of the people who are putting on the activity being negligent, and that's what actually caused the injury, as opposed to the inherent dangerousness of the activity.
Recognize that concern, Your Honor, but I think it again goes back to the fact that this was not just going to the range and shooting weapons. This was going to firearms instruction school. And so going to firearms instruction school, where you're both going to be trained and going to be training others, even to a casual reader, knowing what they were going into, the risk of bad training is apparent there.
I would push back about, I'm not sure that the risk of bad training, certainly it's a dangerousness, and the firearms, and she was an expert in, or certainly had a lot of experience in firearms, but the whole purpose of being there was to learn how to be an instructor. And so when her instructor is telling her, put your finger on the trigger sooner, that seems very different than just the inherent dangerousness that is covered by this release.
I'm out of time, so I would request just a few additional moments to reply. Thank you, Your Honor. I recognize where Your Honor is pushing back there, but I do think it kind of comes back to the idea that of this, say, own negligence. Well, then you would have to be adding our own negligence and the negligence of the trainers and the negligence that you might face in any other aspect of this. It encourages, again, that proliferation that this court has been concerned with. We kind of lose a track between Scylla and Charybdis there, where everything has to be so long that we can't read it, versus so terse that it doesn't mean anything. Unless there's anything other, thank you very much, Your Honors.
Or excuse me, Avenarius versus State is hereby submitted, and the court will take a recess until this afternoon.